everybody, we're going to go ahead and get started. First off, thank you to everybody for coming out. Again, my name is Michael Coker. For those of you that don't know me, this is the Gwinnett Civil Litigators Breakfast, where we're here to kind of share ideas and thoughts about, our cases we have or our practice. And so I wanted to kind of talk a little bit about a topic today that is something that I know is near and dear to all of our hearts, which is still advancing our cases in the time of COVID. And how do we do that? Now, we're going to talk a little about where we stand. I know there's been some recent changes that have come out in the last couple of days. We're going to talk a little bit about that too. But really, what can we do to keep pursuing justice on behalf of our clients? So obviously, here we are. We stand here. The courts have been officially closed for a full year. And as we stand here now, obviously, I never would have expected that when we first shut down last March, that we'd be still having this discussion a year later. And I think a lot of you are probably in the same boat. We've had 12 emergency orders, 12 times, 12 months, the court has shut down anything resembling any sort of jury trial. So we just got Chief Justice Milton's last order yesterday, actually, which lifts the suspension of jury trials. So that's great news. I know I was talking to a lot of friends of mine who are very excited about the fact that jury trials are going to resume. But if you read the order really closely, it doesn't necessarily mean that everything's going to jump back to normal. Obviously, the order says courts may resume jury trials if that can be done safely and in accordance with a final jury plan. There's no requirement that these entities resume or these counties resume the trials. It just says that if you have a plan, if you've spent the time and the money to develop a plan to where you can continue, then we can go ahead and start the jury trials. But that's in May. You're not required to start the trials. This is going to require significant work at the county level. So this is something where this is not going to happen overnight. This is not something where you're going to all of a sudden wake up and we can start jury trials. It's gonna be a financial and time investment for all members of the various counties throughout the state. Obviously, there's problems that remain for us as civil litigators. The first one is I think the biggest concern, which is the backlog of criminal cases. I have friends, obviously, who do a lot of criminal work that have told me the amount of speedy trial demands that have come has been more than they've ever seen in their entire career. And obviously, this means that the court has a requirement that they have to take the criminal case to trial within a certain amount of months, or else the charges, obviously there's issues with the charges themselves. When those cases are going to take priority, obviously we can't have, dangerous criminals running the streets. And so the issue is those cases, as soon as the courts reopen, are going to be the first things that they have to deal with. We're going to be pushed to the back burner. We're going to be pushed behind. We're going to be the ones that kind of have to wait our turn in line. The second issue we're going to face is the type of juror that's going to respond to a jury summons. As a civil litigator, what type of juror do we want? We want someone who's going to understand and be sympathetic to our client, who's going to understand their position. We don't necessarily want the people that are maybe have thrown caution to the wind and don't care about COVID or question the science. That end up showing up and not want to wear a mask or this or that, or not want to engage in safety protocols. So what type of juror are we going to have? And then last, there's some counties that potentially are going to even lack the desire or the financial ability to put the safety measures in place that are going to be required. And I think those counties are just going to shrug their shoulders, unfortunately, and say, there's still nothing we can do because we don't have either the space or the financial resources to go spend a bunch of money to continue with these jury trials. So how do you win your case when your client's access to justice seems still so limited? So I thought this would be a good opportunity for us to kind of put our heads together and try to come up with some ideas that would help us further our client's interest to justice by getting creative a little bit and kind of sharing those ideas. The first idea is on 9/11/68 offers of judgment. Okay, these are something I know a lot of people employ in their cases. The statute's OCGA 9/11/68. It's basically, I've heard it described like this. It's the best description I've ever heard. It's called placing a bet on the value of your case. So you're sitting there you are in Las Vegas and you have to place a bet on what your case is worth. That's in essence what you're doing, and what you're getting in return is the value of the attorney's fees if you guess correctly. This allows the plaintiff specifically to recover attorney's fees from the date the offer is rejected or lapses if judgment post-trial exceeds 125% of the offer. So that's how it applies to plaintiffs. It also applies to defendants if the defendant sends one, and the plaintiff doesn't recover at least 75% of that amount at trial, then obviously the defense is entitled to their attorney's fees. So what is required of an offer of judgment? First of all, it's got to be a tort case. Can't be any other type of case, can't be a contract case, can't be a family law case. It's got to be a tort case. It's got to be in writing. It's got to identify the party making the offer and the party to accept the offer. It's got to identify the claims to resolve. It's got to clearly state any other special conditions. It's got to state the total amount of the proposal. It's got to state the amount to settle the punitive damage claim, if any. It's got to include a certificate of service and be sent by certified mail or overnight delivery, and it's got to be open for 30 days. So how does this happen? So basically, if you go to court, you send an offer of judgment, you end up exceeding it by 125% if you're the plaintiff. How do you end up recovering your attorney's fees? Well, typically, there's an after-trial hearing, the offer where the judge is going to determine a few things. One, was the offer sent in good faith? Meaning, he's going to look at he or she's going to look at the amount of the damages, a realistic assessment of liability, the medical records, the property damage, and say, listen, is this offer, is it in good faith? And then two, should attorney's fees be awarded? Is this a case where the plaintiff or the defendant was trying to get this resolved, was trying to act in good faith, and should attorney's fees be resolved? And three, what the final amount of fees to award? And most courts agree that this amount must be an hourly rate and not a contingency fee amount. So basically that this has got to be something where you can't win in the sense of I charge 40%, for example, when the case goes to trial. I can't collect the 40%. There's case law out there that says that from the Court of Appeals that basically says that they still want this to be tied to the hours or the time worked in the case. So once you send an offer of judgment, it's best to start tracking time and tracking hours to recover those. Why offers of judgment can help us during this COVID slowdown? How can we use these or utilize them? The first and most important thing is it forces the insurance company to revisit and reevaluate your case. So when the case is just shelved, it's sitting there, discovery's pretty much over, nothing's been done. When they receive this offer of judgment, it brings your case back to the top of the stack. They now have to evaluate it, they now have to look at it, and they have to say, is this an offer that we want to entertain and try to accept? Second, it adds a level of danger of pushing off the settlement. So we've heard, and I know that a lot of my colleagues have expressed to me that they're having the same similar issues we are, that insurance companies are basically, they're holding on to their money. Why wouldn't they? The mutual fund or whoever can hold on to the interest, can collect and hold on to their money for a longer period of time as they wait for the trials to appear. This puts a level of danger in doing that, because now that interest that they may have earned on their money all of a sudden is going to be potentially eaten up or potentially exceeded by the attorney's fees in the case. And last but not least, it shows your client's willingness to settle now, but still is a power play. It still shows strength. So you're not calling, looking desperate and saying, do you guys want to settle this case? It's giving an offer, showing a willingness to settle, but still maintaining that position of power in the negotiation. There we go. What are some of the potential pitfalls of offer of judgments for civil litigators? First, they're only permitted in tort claims. We talked about that, so not contract claims. So there's some argument in some case law that these do not apply to UM carriers. So you can't send an offer of judgment to a UM carrier a lot of times that's not going to be beneficial, and it's not going to even be valid. Is what the arguments have been made. The second thing is your client's often going to receive an offer of judgment in response. So basically, if you have a situation where you send an offer of judgment, maybe you have a wealthy client with a lot of assets and they get one back, that could potentially spook them or scare them that they could be personally on the hook for the defense's attorney's fees if they don't hit that 75% mark. So you got to really evaluate the type of client that you have to see if it's someone who's going to get spooked or want to just quickly settle the case if you get one in response. And last, when there's multiple insurance layers, it can extinguish the claims for other policies. So let's say you have a $50,000 liability policy and a $100,000 UM policy. You want to send a $50,000 offer of judgment. You are asking the court or asking the opposing party, in essence, to agree to a judgment in the amount of the $50,000. So basically, you are asking them to agree to a judgment in $50,000, and so that would potentially extinguish your claim for the $100,000 on the UM, which would come after. Now, I've seen attorneys try to get creative and send offers of judgment that ask for a limited liability release, but there is also some argument that that is not a judgment per se. It doesn't extinguish the claim. And so therefore, even if you were to send that, you may be opening up the door for the defense or the insurance company to later argue that that was not a valid offer of settlement. The next thing you can do is ask for status conferences. And this is something we've really tried to utilize in a bunch of our cases. Judges are willing to host virtual status conferences, mostly via Zoom, where basically you get on with the defense counsel and the judge, you talk about issues, talk about ways to maybe move the case forward. They can be requested by either party. Obviously, you might be able to pick up the phone, call the defense lawyer, and they may just consent to it, and they may agree to having one. It forces the opposing counsel to appear in your case. So that's something that's nice too, is again, getting your case on a stack on somebody's desk back to the top of the stack is always something you want to be tried to do during this period. Last, you want to address any outstanding motions or issues. Is another thing that's good, that's helpful. So if there's an outstanding motion for summary judgment, if there's an outstanding discovery dispute, it allows it to push those forward and not just be left open kind of in perpetuity. This is a benefit sometimes. You'll get a mediation recommendation from the judge. The judge may say, listen, is this something you guys are willing to mediate? Go sit down and try to see if you can get this resolved. And sometimes that's nice, having that recommendation come from the judge, again, instead of coming from you or your client. Again, it doesn't give up or show any sort of weakness there. And last, it allows you to get clarity on the county's plan for reopening. So you can get some ideas of what's going on, and this has been very helpful for me. I had one this past week with Hall County, and they explained to us when they anticipate they're going to start up the civil jury trials again. When their hope is, what they think they're going to continue, their plan, how they're going to handle them. So it's been real nice to kind of be able to digest that information, put a plan into place to kind of prep that case and get it ready for trial. The last kind of non-traditional thing that you can try to do is these non-traditional trial methods. And I've seen actually other lawyers have some success with this recently. The first one is bench trials. I know historically most civil litigators are opposed to bench trials, but given the circumstances and if you have the right type of case, it might make sense. The pros are it allows you to try your case immediately. There's senior judges that are eager to get back to work, that are willing to try a case. You could probably pick up the phone and find a senior judge willing to try the case next week if you wanted to. It allows your client to get justice now. So they don't have to wait behind that criminal backlog and then the civil backlog to get put at the back of the line to try their case 2 years from now. They can go get justice right now. The cons are you're obviously not going to have the large jury verdicts. You're at the mercy of the judge that you get this assigned to you. Obviously, we know that some judges tend to favor defense, some tend to favor plaintiffs. So you're somewhat at the mercy of that. And then in-house counsel, one of the cons is that many of them are agreeing to bench trials for some of the insurance companies, but only if you cap the damages at $25,000. So that's kind of how they hedge their bets, is they say, we'll do a bench trial, but only if you agree to cap the damages at 25,000. But the good news is maybe you've got 6, 7, 10, 12 cases that you don't think are worth over 25,000 that you could move along, get in there, do a bench trial, and keep it moving. The second kind of non-traditional method is a 6-person jury. Obviously, you know, most of our juries that we have are 12-person juries, but having a 6-person jury is something that is going to allow counties that lack the space or maybe the resources to have a full jury pool to accommodate you or to accommodate your case. It puts your case at the front of the line. This is another benefit. A lot of the judges that I've been talking to in these status conferences have been telling me, hey, listen, you know, Michael, if you'll agree to a 6-person jury, we'll get you in as soon as we can accommodate, as soon as we can, because I think they're viewing these 6-person juries somewhat as a trial or a test in their ability to perform these jury trials. And so if you're a lawyer and you agree to do a 6-person jury, I think that's a fast track way to get your case to the front of the line. The cons are that it requires the consent of all parties if the damages exceed 25,000. So if you're seeking more than 25,000 in the case, you're going to have to get the defense lawyer to agree. And a lot of defense lawyers will not agree to a 6-person jury because their idea is that all they have to do is find one person to basically dissent, to basically, you know, throw everything and blow everything up. And they'd rather have, on the odds standpoint, 12 people to find one versus 6. So you're going to have a hard time on your bigger cases getting the defense lawyers to agree to that if it exceeds 25,000. But I don't know, maybe they want to move it too, and so maybe you'd be surprised. There is a rumor that legislation's being pushed to up that $25,000 limit. So basically that the defense can object. There's been different discussions, some of it 50,000, some 100,000, about whether or not that limit's going to be pushed, that cap on the 6-person. But I have not heard any update on that lately, and I'm not sure where that's going to go. The last kind of non-traditional method is arbitration. And I know arbitration is something that a lot of people have scoffed at. I have friends that do nursing home litigation, and so obviously they see a lot of arbitration in a lot of their cases. And it's funny, they've started just agreeing to some of these motions for arbitration just as a way to get a quick resolution of some of these cases. Obviously, the pros are it shortens discovery, it narrows the issues, and it provides for an immediate binding resolution. But the cons are there's no large verdicts. It requires an agreement on the arbitrator or the arbitrators that you use, and there's obviously some dissension. Obviously, you're going to want arbitrators who think are going to be friendly towards your client. The opposing party is going to want ones that think they're going to be friendly to their client. It also provides for an immediate binding resolution. You'll see I've got that both in the pros and the cons, because obviously, if you get a good binding resolution, you're happy, but arbitration can also obviously quickly turn and you can end up with an equally bad situation. So those are just some ways that you know, I wanted to start the discussion of kind of how we can go ahead and kind of win our cases in an era when jury trials aren't existing. And I put this quote up here. I'm a big fan of kind of Romans and Roman philosophy. It says the foundation of justice is good faith. And I believe that if you do everything that you can to pursue justice on behalf of your clients, that this is something that you will be able to achieve that for them. Even in these hard times, that's something you're going to have the ability to go in there, do the best you can for your client. It might take you getting creative. It might take you doing some things that you've never done before, but I think you can still continue and move forward. So I just wanted to say, thank you for coming out today. Hope everyone's enjoyed their breakfast, and we will see you next month.